So the first case we're going to discuss is a New York case, and it is important in my view for two reasons. First, the basic principles that it applies, I think, are applicable around the country, no matter what jurisdiction it is. And second, I think it may signal a dramatic change in New York law. It's the By Economy v. Harleysville case, and really the question that I find most interesting is it signaling a sea change in New York law? Because up to now, New York has effectively recognized no cause of action for first-party bad faith. It says there is such a cause of action, but I've only seen one or two cases where it's survived a motion to dismiss, much less actually gone to trial. So here are the key facts. There's big fire in By Economy Market, which is a small retail market. Harleysville was providing property and BI coverage. Harleysville paid the $163,000 towards the property and only 7 months of BI, even though the policy provided 12 months of BI, and the claim is the market was very severely damaged. They go through an ADR proceeding, which, although not described in the opinion, is apparently appraisal under the property policy, and By Economy is awarded another $250,000 in property damage. No reference in the opinion to whether the BI claim went into appraisal or what happened to it, just they got another $250,000. So By Economy sues. And they alleged bad faith and breach of contract and sought consequential damages, claiming that the insurance company's failure to pay caused the complete demise of the business operation. Basically, it's small business, didn't collect hundreds of thousands of dollars in insurance proceeds, gone. By Economy claimed that Harleysville improperly delayed payment, failed, obviously, to timely pay the full amount of the BI claim, and the lower court granted summary judgment on two bases. One is the consequential loss exclusion, and it's not quoted in the opinion, but a typical exclusion, which I pulled out of one of my policies from another case the other day, reads something along the lines of the following. We will not pay for loss caused by or resulting from delay, loss of use or loss of market, interruption of business, or any consequential loss of any kind. And the lower court held policy doesn't cover consequential loss, no consequential damages are recovered. And then the lower court also held that the claimed consequential damages were not contemplated by the parties at the time the contract was formed. So the Court of Appeals of New York, which for those of you from out of town is the Supreme Court of New York, reversed. And the court started by addressing foreseeability of consequential damages for breach of an insurance contract. And the basic concept involved is really first-year contracts course, that if there is something that the parties specifically contemplated or was reasonably foreseeable that would be a consequence of a breach, then that is a recoverable damage in addition to the contract proceeds itself. But it has to be either specifically contemplated or reasonably foreseeable. It can't be something that just, whoops, 3 years later it happens. So New York law, as in many states, has exactly that principle as to consequential damages under a regular contract. Forget insurance. Then the court went on and I think went far beyond what it needed to do and muddled things in a way that will be very interesting possibly for years to come. Court went on to say that as in all contracts, implicit in contracts of insurance is a covenant of good faith and fair dealing. And nothing controversial there, such that a reasonable insured would understand that the insurer promises to investigate in good faith and pay covered claims. And that may all be well and good, but it has nothing to do with consequential damages. This is the point that I think will be used around the country. The purpose served by business interruption insurance cannot be clearer: to ensure that By Economy, and insured, had the financial support necessary to sustain its business operation in the event disaster occurred. That is precisely the reason everyone buys business interruption insurance, unless you're DuPont and you buy it simply because you don't want to get sued for not properly insuring your business. But the point is that most businesses, particularly smaller businesses, without BI coverage, if they're shut down for 6 months to repair fire damage, they are gone. And this is a very, I think, non-controversial statement, but it's never been said that I've seen in any insurance coverage case before in this way, and it's a determination as a matter of law. Court went on to say that if you limit the insured's recovery just to policy proceeds, you're not putting the insured in the same position the insured would have been had the contract been performed. That's another non-controversial statement. I think it's fairly obvious. And this is really what I now quote to insurance companies when I talk about why they need to pay faster. Court held as a matter of law, the very purpose of business interruption insurance would have made Harleysville aware that if it reached its obligations under the contract and failed to pay covered claims, there were going to be consequential damages, particularly of this type. Now, again, it goes on, the court went on to say to investigate in good faith. You don't need that, in my view, to recover consequential damages under basic contract law. So this is, I think, the first far-reaching holding, and it applies not only to BI insurance but to property damage insurance. Because why do you buy it? You buy it to repair. Imagine a homeowner, if you would, has property insurance. You need it for the mortgage. The mortgage will usually require the homeowner to repair the house in the event of a casualty. If the company doesn't pay and the homeowner can't afford to repair and the mortgage gets foreclosed and he loses his house, that, in my view, is a foreseeable consequential damage. And I think it'll be very hard for an insurance company to say, oh, we had no idea why the policyholder was buying property damage insurance for his house or BI insurance for his mom and pop store. The court also held that the consequential loss exclusion does not apply to consequential damages for breach of contract. And this, I think, will also be useful around the country because lots of courts have made exactly the same argument that Harleysville made in this case, which is the policy excludes consequential loss, therefore you can't recover consequential damages for breach of contract. And the court in By Economy explained the difference between a consequential loss arising as a result of the covered peril, i.e. you have the fire damage, but then because of the fire damage, you lose a contract because you can't be up and running. That's a consequential loss. Consequential damage for breach of contract has nothing to do with the insured peril. It has to do with whether the insurance company has paid on time and in full. And I think that this is an intellectually correct distinction.